C. Make public the present decision and disseminate its content widely, with a view to prevent similar violations of the Convention in the future.
The United Nations has found New Zealand breached the Convention Against Torture by failing to properly investigate abuse at Lake Ellis Hospital in the 1970s. A victim took the case to the UN because the psychiatrist accused of electrocuting patients as punishment has never faced charges.
Paul says in 1974 he was diagnosed with a behavioural disorder by psychiatrist Selwyn Leeks, who he claims then tortured him.
They have you sitting in the chair or they have you laying on the bed. Nurse is holding you down, you've got no choice.
Repeated attempts to contact Leeks, who now lives in Australia, have been unsuccessful, but he's always denied wrongdoing.
Do you apologise for anything?
No, I don't think I do.
No matter what the government officials say, torture on the testicles is pretty serious.
We are the revolution. We want it all tonight. We want to take back what's rightfully ours. We are
Varian, are you going to say hello to everyone? Come here, say hello. Yes. He likes the whiskers, he just likes to clean the fleas off his face. Don't you, Varian? My boy. Just my boy. Say hello. This is my big boy. Varian. Aren't you? Loves his daddy. Alright. Come here. Give me more cuddle. Rightio. Part 2. So I'll continue. We're up to 5.1 of the UN decision on New Zealand being found guilty of torturing children in state hospitals. Right, so complaints, comments on the state party's observations, or complainants' comments. So this is what Paul has to say. 5.1. The complainant submitted his comments on the 23rd of December 2018. He contends that instead of fully investigating the claims of punishment, ill treatment and sexual abuse at the Lake Ellis Hospital, the state party conducted very limited inquiries and investigations that avoided seeking any accountability for what occurred. The 4 inquiries and investigations that took place in 1977 looked at isolated complaints and exonerated the psychiatrist in charge of the child and adolescent unit, along with other medical staff and authorities involved. 5.2. Early 2000s, when the state party had almost 100 claimants who alleged ill treatment, physical abuse and punishment, and sexual abuse, instead of an open court action, there was a negotiated settlement and ex gratia compensations, and an apology to almost 200 former child patients of Lake Ellis. What the state party did not bank on was that the former High Court judge assessing the claims would write his own uncommissioned report on what he had found when investigating the Lake Ellis cases. And this was reported on the New Zealand media, thus further exposing the level of cruel ill treatment of children in state care. 5.3. The complainant then refers to the different Lake Ellis inquiries and investigations. The state party claims that the 1977 Commission of Inquiry and the report issued by Chief Ombudsman responding to isolated complaints of abuse at Lake Ellis were significant in that they were contemporaneous to the alleged abuses. However, in his 2001 report, Sir Rodney Gallen explains why these inquiries were not adequate in the way the children's complaints were discounted. He found the accounts of the claimants to be consistent and supported by medical notes. It was this report the government considered evidence that ill treatment did occur at Lake Ellis. For the first time, the state party had in their possession comprehensive information from over 90 former child patients of Lake Ellis, detailing what happened to them in the 1970s. The statements and records had never been collectively examined by former inquiries and investigations. Thus, Sir Rodney Gallen was able to determine that unmodified ECT was used routinely on the children as punishment. 5.4. Because the medical authorities in New Zealand and Australia refused to pursue any case against Dr. Leakes after he resigned as a practitioner, he was never answerable to them, nor any medical practitioner's code of conduct. This left the police and the complaints that were filed with them in 2002 and afterwards as the only possible recourse for accountability for what occurred. However, even if police had access to the most comprehensive evidence as to what occurred at Lake Ellis, they essentially took the same path as the 1977 investigations and looked at just one case and claimed there was no criminal liability. Cover-up. 5.5. As to the 6-month time limit for commencing proceedings under the Mental Health Act 1969, the complainant alleges that Section 124 of that Act would have been applicable to the Lake Ellis claimants, who first learned that they were able to pursue avenues of criminal complaints sometime after they received a formal government apology and a financial payout in 2001-2002. 5.6. As to the police statement under the Crimes Act 1961, willful cruelty to children may be a difficult charge to pursue. The complainant considers there was a lot of corroborating statements by former patients, as well as reports and statements of persons whose advice was sought by the police. With the wealth of information before them, it is surprising that they could not mount a criminal complaint against the psychiatrist and certain staff from the unit. The complainant believed the police languished with their investigation before they made their final report in 2010. During this time, they had interviewed only one of the 41 people who had filed for criminal complaints, whereas Sir Rodney Gallen had managed to interview 41 complainants for his report in much shorter space of time. Just like the inadequate investigations in the 1970s, it appears that the police chose not to look at all of the Lake Ellis cases in detail and collectively in terms of their corroborative evidence. Their reasoning is inadequate given the high profile and public interest in this case. 5.7. Referring to the countervailing public interest, the complainant submits that during the period police had the complaints, the public interest in the abuse of children in state care never waned. In 2004, the state party recognised the underlying problems experienced by historical abuse claimants. In 2004, the state party recognised the underlying problems experienced by historic abuse claimants and established a confidential forum as a means for people who were in psychiatric hospitals and institutions to discuss their experiences. Then, in 2008, the government opened up a wider forum with confidential listening and assistance service for victims of psychiatric and state care abuse and neglect. A number of 1,103 people came forward over a period of 7 years. That's disgusting. 5.8. Contrary to state parties' allegations, the abuses at Lake Ellis Child and Adolescent Unit continued to be in the public interest and in the news. In a very recent television broadcast on November 25, 2018, An investigative journalist reported on the failure of the police to properly investigate the claims of ill treatment and criminal wrongdoing at Lake Alice. This indicates that there may well have been grounds for a prosecution for alleged offences committed in the Lake Alice unit. It also appears that there might have been reasons other than stated in state party reports not to prosecute any of the Lake Alice cases. 5.9. The interest is still strong with the New Zealand government, having announced in February 2018 that there will be a Royal Commission of Inquiry into historical abuse in state care, and in November announcing the terms of reference. This should be the largest inquiry of its kind in New Zealand history, as it is set to span for a period of 4 years. 5.10. In response to the alleged delay in submitting his communication, the complainant mentions that he had submitted his complaint to police in 2006. In 2010, he received notification that the police would not be instituting a prosecution against Dr. Leakes or any of the staff in the hospital's authorities at Lake Alice. In 2015, the complainant requested the police file relating to his complaint and found there was possibility of a criminal charge. It was 2 years after this discovery that he decided to take this case to the committee. 5.11. The state party is confident that similar events will not take place again due to the safeguards within the legislation surrounding psychiatric treatment. There are, however, no guarantees that future serious allegations of ill treatment, physical and sexual abuse of psychiatric patients, young or old, will not be covered up in the way the cases and complaints of Lake Alice have been. Through official channels, obfuscation and not actually believing the patients and their complaints, especially at the time or near the time they occur, but not conducting a full and independent inquiry either through medical, civil or criminal courts. The events of Lake Alice have never been properly aired through an open examination which such courts provide. 5.12. The state party raised a criticism of the Gallen report 2001 did not take into account the views of the staff, the nurses or the doctors of Lake Alice, but the government had never provided the opportunity nor the forum to air those views. The announced Royal Commissioner of Inquiry may be the only avenue left to investigate the Lake Alice cases in an open and unbiased forum. However, it is not certain that this inquiry will scrutinise why the police did not mount a full investigation of the Lake Alice complaints and lay charges against Dr. Leakes and certain former staff, or the failure of the Medical Council to pursue the serious complaint in 1977, and to allow Dr. Leakes to leave the country and later resign without actually investigating his practice. 5.13. The state party had a duty of care to the young people who went into Lake Alice. It was not enough to conduct superficial investigations and pretend these were isolated incidents and their children not credible witnesses. Nor was it enough just to make ex gratia payments to victims claiming no liability when many of them wanted those responsible to be held accountable. The state party could take further steps to ensure this complaint is fully investigated and those responsible for what occurred at Lake Alice are held accountable for their actions. Additional submissions from the state party. 6.1. On 15 May 2009, the state party provided further observations as to the allegations that police investigations conducted between 2002 and 2010 were inadequate. The state party explains that the decision in early 2000s to choose a representative complaint for analysis was an exercise of police prosecutorial discretion. Sounds more like prosecutorial misconduct to me. It was and is accepted practice that complaints which raise common legal issues are able to be examined on a representative basis. This did not mean that the other complaints received were ignored. Similarly, when the complainant made his complaint in 2006, police had access to past complaints and were able to analyse the legal issues that were common to the decision they were required to make as to whether to prosecute. Dr. Leakes, in light of the steps already undertaken by police and the information that police had from prior investigations into Lake Alice Hospital, the criticism that police did not interview a sufficient number of victims is not valid. Really, they had over 100 complainants and they interviewed one. That's valid. And it was not a breach of the state's party's Article 12 obligations. 6.2. As to the allegation that the 6-month time limit for bringing a charge of neglect or ill treatment of a mentally disordered person under Section 112 of the Mental Health Act 1961 could be extended by applying Section 124 of that Act, the state party submits that the New Zealand Court of Appeal has rejected the proposition that the 6-month time frame within which applications for leave must be brought if a party wishes to commence civil or criminal claims in respect of acts done in the pursuance of the Mental Health Act 1969 only starts to run from the cessation of the inquiry or damage to the person who wishes to bring the action or prosecution. As such, in 2010, police were correct to determine that no charges could be brought against Dr. Leakes under the Mental Health Act. Typical. 6.3. The state party advised the committee that allegations of sexual assault at Lake Alice Hospital are currently being investigated by police. The catalyst for this investigation was 3 witnesses coming forward to make complaints to the police in early 2019. Or what about the 100 complaints made before that? So they're happy to do it now that 3 complained in 2019. Again, piss poor New Zealand police. Police did not pursue allegations of sexual assault at Lake Alice Hospital between 2006 and 2010 because the claims at that point were considered too vague to properly investigate and or the suspect and or complainant was dead. Yeah, because they left it for so fucking long. The fact police had opened an investigation into matters concerning Lake Alice Hospital in response to recent complaints demonstrate that police continue to be responsive to complaints relating to this matter. 6.4. In November 2018, an independent inquiry into New Zealand's mental health system recommended that the Mental Health Compulsory Assessment and Treatment Act 1992 be repealed. The government, in considering that the recommendation presently, the government is considering that recommendation presently, and work is already underway to revise the guidelines under that Act. These revisions seek to align the application of the current legislation as closely as possible to the obligations under the Convention of the Rights of Persons with Disabilities. 6.5. The term of reference of the Royal Commission of Inquiry into Historical Abuse in State Care have been finalised. The inquiry will consider the experience of children, young persons and vulnerable adults who were in care between 1 January 1950 and 31st December 1999. For the purposes of the inquiry, state care includes psychiatric hospitals or facilities, including all places within those facilities. Accordingly, events at Lake Alice Hospital during the 1970s fall within the terms of reference of this inquiry. The complainant and others who were patients at Lake Alice during that time will be able to make submissions and participate in the inquiry process. The inquiry may directly comment on the events at Lake Alice Hospital during that period and the lessons which can be learned from those events. The Commission will have extensive powers, including the power to summon witnesses and the power to require any person to produce information to the inquiry. The inquiry is to deliver its final report to the Governor General of New Zealand by 3 January 2023. The final report must be presented to the House of Representatives as soon as practical after that date. In light of these comprehensive reviews, the State Party has complied with and will continue to comply with its Article 11 obligations. Will it just? What about Article 17? You seem to be messing with people's families all the time, State Party. This is just Crown law making millions. Additional submissions from the complainant. 7. On the 22nd of May 2019, the complainant records that the new police investigation into allegations of sexual assault, the revision of the guidelines under the Mental Health Act 1992 and the Royal Commission of Inquiry have transpired since his initial complaint to the committee. In the matter of the Royal Commission of Inquiry, there has been recent announcements that the Commission will begin hearing evidence from people who have been in institutions early 2020. It is being proposed by the Minister of State Services that the government response to the Commission as concerns become evident, rather than wait until 2023 when the Commission is due to complete its work. Therefore, it may also be reasonable to see what transpires from the Commission's investigation into Lake Alice. With its ability to summon witnesses, it might well uncover information as to why earlier medical, government and police investigations did not amount to anything. Issues and proceedings before the committee. Considerations of admissibility. 8.1. Before considering any complaint contained in a communication, the committee must decide whether the complaint is admissible under Article 22 of the Convention. The committee has ascertained, as it is required to do under Article 22 subsection 5 subsection A of the Convention, that the same matter has not been and it is not being examined under another procedure of international investigation or settlement. 8.2. The committee notes that the State Party submits 4 sets of arguments relating to the admissibility of the communication, which it will examine separately. 8.3. Firstly, the State Party argues that the complainant's allegations under Article 2, 10 and 11 of the Convention should be declared inadmissible rationale temporis. The complainant has not commented on this aspect. The committee notes that the impugned events took place between 1974 and 1977, while the complainant was admitted to the Child and Adolescent Unit at Lake Alice Hospital. At the State Party's declaration pursuant to Article 22 subsection 1 of the Convention was effective from the 10th of December 1989, the committee observes that even through the alleged ill-treatment even though the alleged ill-treatment preceded the adoption and entry into force of the Convention for the State Party, the prohibition of torture and other ill-treatment was nonetheless universally accepted and absolute at that time. The committee recalls that the State Party's obligations under the Convention apply from the date of its entry into force for that State Party. However, the committee can examine alleged violations of procedural obligations under the Convention which occurred before a State Party's ratification or accession to the Convention, or recognition of the committee's competence through its declaration under Article 22, and of other obligations that have similar legal effect under the Convention. In that connection, the committee notes that both the filings of the complaint to the police and the police decision not to investigate Dr. Leakes occurred after the entry into a force of Article 22 of the Convention for State Party. Therefore, the committee considers that while the acts of ill treatment occurred between 1974 and 1977, the contested investigation of those acts by the State Party is within the committee's competence rationale temporis. 8.4. Secondly, the committee notes the state party's argument that the complainant's claim related to decisions by Australian institutions are inadmissible as the impugned acts of agents took place outside the state party's jurisdiction, paragraph 4.11. The committee considers that it is precluded rationale loci from examination the complainant's allegations in respect of the acts committed outside the state party's jurisdiction. 8.5. Thirdly, the committee notes that the state party's arguments relating to the lack of exhaustion of domestic remedies by the complainant, according to the state party, on one hand, the complainant has not contested before the courts the medical council's decision not to investigate Dr. Leakes, and, on the other hand, he has had the opportunity to participate in the newly established Royal Commission of Inquiry into Historical Abuse in State Care. The committee notes that, although the complainant has not disputed the possibility of contesting the decision of the medical council before the courts, the committee considers that the procedure before the medical council, which the state party itself admits that it is independent regulatory body, cannot replace a criminal investigation into the facts alleged by the complainant. The committee also notes the state party's acknowledgement that the new Royal Commission of Inquiry has no power to establish criminal liability. The committee therefore considers that no additional effective remedies were available to the complainant for his claims under Article 12 and 13 of the Convention. Didn't like that much, did you, state? 8.6. Fourthly, the state party invokes Rule 113 subsection F of the Rules of Procedure to claim that the time elapsed since the purported exhaustion of domestic remedies is unreasonably prolonged as to render consideration of the claims and relief sought by the complainant unduly difficult by the state party. However, the committee notes that the complainant's uncontested assertion that he received the police notification in 2010 and that he requested the police file in 2015, on which occasion he became aware of the possibility of a criminal charge for the treatment received at Lake Alice Hospital. The committee points out that neither the Convention nor the committee rules of procedure establish a time limit for submitting a complaint. While the complainant does not explain why it took him 5 years to request the police report of investigation, the committee notes that he introduced his communications in 2017, that is, 2 years after becoming aware of the details of the police investigation. Consequently, the committee finds that there are no obstacles to admissibility under Rule 113F of the committee's Rules of Procedure. 8.7. The committee noted that the complaints do not provide any arguments to explain how his rights under Article 2, 10 and 11 of the Convention have been violated. Therefore, the committee considers this part of the complaint to be ill-founded and declares it inadmissible pursuant to Article 22.2 of the Convention. However, the committee notes that the complainant's claim that the state party has not ensured accountability for the treatment that he suffered while at Lake Alice Hospital, which is contrary to Articles 12 and 13 of the Convention. The committee considers that the committee finds no further obstacles to admissibility. It declares this part of the communications containing claims under Article 12 and 13 of the Convention admissible and proceeds with its consideration of the merits. Moreover, the committee considers that the complainant's claims are admissible insofar as they raised issues under Article 14 being considered in the present case in relations with Article 12 and 13 on the procedural aspects of the right to justice and to the truth. Consideration of the merits. 9.1. In accordance with Article 22.4 of the Convention, the committee has considered that present communications in the light of all information made available to it by the parties. 9.2. The committee notes that the main issue before it consists in determining whether the complainant's allegations of abuse by staff of the Child and Adolescent Unit at Lake Alice Hospital between 1974 and 1977 have been promptly and impartially examined by the competent authorities in accordance with Articles 12 and 13 of the Convention. The Committee recalls its jurisprudence that a criminal investigation must seek both to determine the nature and circumstances of the alleged acts and to establish the identity of any person who may have been involved therein. This is not an obligation of result, but one of means. The Committee must therefore assess whether the authorities of the state party have taken reasonable steps available to them to conduct an investigation that is capable not only of establishing the facts, but also of identifying and punishing those responsible. Good. 9.3. The Committee first notes that the state party does not contest the events that took place in the 1970s at Lake Alice Child and Adolescent Unit. Complaints for those events were first filed already in 1976, with the complainant participating in the 1977 Commission of Inquiry. According to the police report dated 22 of March 2010, that unit closed in 1979 following concerns about supervision and a number of critical investigations. The Committee also noted that the state party does not contest that the complainant was a victim of those events. The letter of apology that the complainant received on or around the 23rd of December 2002 mentions that the government apologised for the treatment that the complainant received and may have witnessed in that place. The Committee also notes that the state party does not contest that the treatment alleged by the complainant meets the threshold of torture as defined in Article 1 of the Convention, or at least of ill treatment as defined in Article 16 of the Convention. 9.4. The Committee further notes that in his 2006 complaint to the police, the complainant referred to the application of electric shocks and administration of drugs as punishment, as well as instances of sexual offending at a time when he was still a child in state care. However, despite the gravity of these allegations and his particular vulnerability as a child at the time of the events, and also despite the findings by a retired High Court judge that ECT was constantly used on children as punishment, the Committee notes that, following a police investigation which lasted for over 3.5 years, the resulting report dated the 22nd of March 2010 did not clarify whether the alleged treatment was indeed applied as punishment. That report takes note that there is evidence of the application of ECT in both treatment modes. There is also evidence of the application of electric shocks in circumstances that might suggest use as a form of aversion therapy or punishment. The report also mentions that this is the 7th examination of these related facts. In this connection, the Committee recalls its recommendation to the state party to investigate promptly and impartially the allegations of ill treatment in the historic cases and to prosecute the perpetrators. The Committee also recalls the state's party response that although Police Complaints Authority may technically decide not to action a complaint of torture where the complainant has had knowledge for more than 12 months before the complaint was made, however, given the seriousness of the accusation, it is likely that the authority would investigate historic complaint of torture. The Committee further recalls its findings in 2015, concluding observations of the state party's 6th periodic report that the state party failed to investigate or hold any individual accountable for the nearly 200 allegations of torture and ill treatment against minors in Lake Alice Hospital, together with its recommendations to conduct prompt, impartial and thorough investigation into all allegations of ill treatment in healthcare institutions and prosecute persons suspected of ill treatment. The 2010 police report also notes that the immense and ongoing media interest in this case, therefore, the Committee expresses concern that despite repeated investigations into the same matter, a police acknowledgement of evidence of the application, and the state party's acknowledgement before the committee of the seriousness of historic complaints of torture, and while admitting the continuing public interest into the matter, the authorities of the state party made no consistent efforts to establish the facts of such a sensitive historical issue involving abuse of children in state care. They have also failed to expressly acknowledge and qualify the alleged treatment inflicted to the complainants. 9.5. In its observations, the state party claims that the decision not to prosecute Dr. Leakes was informed by a lack of evidence and a determination that there were no other countervailing public interest in proceedings with the prosecution. However, the state party has not demonstrated that it made sufficient efforts to clarify the facts. The state party admits not only that complaints related to treatment at Lake Alice Hospital in the 1970s began to emerge and continued since 1976, but also that as recent as 2018, a Royal Commission of Inquiry was established to look into historic abuses in state care, including the Lake Alice Hospital events, and that new related complaints brought in 2019 are being investigated by the police. In the absence of convincing explanations by the state party, did you not manage to be convincing, Crown Law? The committee fails to see why there is no countervailing public interest in proceeding with prosecution. The case concerned violence in state care inflicted upon a vulnerable group, and independent bodies cannot be delegated to decide on criminal matters. In that connection, the committee notes that the Medical Council also refused to take action by accepting cancellation of Dr. Leakes' medical practicing registration. The state party endorsed such an act, leading to impunity, despite its obligations to protect against abuse of those in a vulnerable position and with no other legal possibility to take further their allegations before the competent authorities. 9.6. The 2010 police report further mentions that the charges were only considered in relation to the guilt of the main suspect, Dr. Leakes, concluding that there was unlikely to be sufficient evidence to successfully prosecute a charge of willful cruelty to a child. The committee expresses concern that the authorities have not tried to find out if somebody else could be held responsible for the alleged violations, which raised doubts as to the effectiveness of the police investigation. Exactly. Which should be capable of identifying those responsible for the violations. 9.7. The committee further notes that the police investigations attached significant weight to the fact that an appropriate charge for the police to consider on the facts was time-barred by a 6-month time limit. However, neither the state party's observations nor the police have analysed if the complainants, who was a child when suffered the treatment, could have effectively complained in the 6-month time period after he was released from the Lake Alice Hospital, where he was sent by his own mother. The committee notes that the complainant stayed there until 1975 and then provided submissions to the 1977 Commission of Inquiry. In this connection, the committee draws attention to the state party's obligations under Article 12 of the Convention to ensure that its competent authorities proceed ex officio to a prompt and impartial investigation, whether there is reasonable ground to believe that an act of torture has been committed. The committee notes that it is only in 2003 that the government invited former Lake Alice victims to make a criminal complaint to the police, and yet, in spite of this express invitation, the police has still to date not clarified the facts surrounding those events. 9.8. Finally, the committee notes that when confronted with several complaints in respect of the events at Lake Alice Hospital, the investigative authorities of the state party chose only a representative complaint for analysis. The committee considers that in that specific circumstances of such undisputed historical complaints, choosing to analyse only one complaint triggered the risk of ignoring the systemic character of this issue as at stake and all the surrounding circumstances. 9.9. In light of the abuse, the committee considers that the state party's failure to conduct an effective investigation into the circumstances surrounding the acts of torture and ill treatment suffered by the complainant while admitted at the Child and Adolescent Unit of Lake Alice Psychiatric Hospital is incompatible with the state's party's obligations under Article 12 and 13 and 14 of the Convention to ensure that competent authorities proceed to a prompt and impartial investigation wherever there is reasonable grounds to believe that an act of torture and ill treatment has been committed. 10. The committee, acting under Article 22.7 or 22 subsection 7 of the Convention, decides that the facts before it reveals violations by the state party of Article 12, 13 and 14 of the Convention. 11. The committee urges the state party to A. Conduct a prompt, impartial and independent investigation into all allegations of torture and ill treatment made by the complainant, including, where appropriate, the filing of specific torture and or ill treatment charges against perpetrators and the application of the corresponding penalties under domestic laws. B. Provide the complainant with access to the appropriate redress, including fair compensation and access to the truth, in line with the outcome of the investigation. C. Make public the present decision and disseminate its content widely, with a view to prevent similar violations of the Convention in the future. Okay, which is what I'm doing. I'm making public the present decision and disseminate its contents widely. So all of my friends in America and in England and everywhere else in the world, feel free to share this far and wide, because that's what the committee is asking. Right, 12. In accordance with Rule 118, subsection 5 of its Rules of Procedure, the committee requests the state party to inform it within 90 days of the date of transmission of this decision of the steps it has taken in response to the above findings. So the police have decided to reopen an investigation, so I hear. As far as I know, they haven't followed that 90-day guideline. The Crown has been dicking around. They've been rescheduling appointments with Paul to discuss the matters and basically giving him the good old jerk around. So I'm going to keep you guys apprised. I'm also hoping to, in the future, to do a full and frank interview with Paul, so he can tell everyone what happened to him in his own words. You guys can all listen to it. Hopefully Paul's okay with it, and because Paul, like myself and a few others in New Zealand, are sick to death of the lack of accountability and transparency. These bastards that are given authority by our say-so are abusing that authority. The judicial system is not independent, and even judges like Judge Boucher, the head of the family courts, has been found to be tantamount to committing hang on, let's just read this one. This is the Economic and Social Council from the Commission on Human Rights, 56th session. I'll read out the observations, section 217. And this is about Judge Boucher, the crook, that one. There appears no doubt that the police withdrew the prosecution based on the injudicious comments of Judge Boucher on the credibility of Mr. Motu Singh, who was the complainant. Judge Boucher was not the judge in the trial in which Mr. Singh was the complainant. Judge Boucher's conduct is tantamount to her having interfered in the administration of criminal justice in the matter, resulting in the integrity of the judge being brought into question. The Special Rapporteur expresses surprise and concern over the fact that there is no procedure that in New Zealand to discipline judges for such misconduct. Now this finding was made just before they brought out the JCC, or Judicial Conduct Commission, which is an absolute joke. As I've mentioned before in previous videos, over 1,800 complaints have been made to the JCC and 0 have been upheld. So they are just gatekeepers, saving the judges from any redress. Moving on, there is no procedure in New Zealand to discipline judges for such misconduct. Mere expression of regret by the judge concerned for such misconduct may not help to command respect for the independence of the judiciary. Legislation providing for a discipline procedure to deal with complaints against judges with adequate safeguards as provided in Principles 17 and 20 of the Principles on the Independence of the Judiciary is not inconsistent with judicial independence. So again, Judge Boucher brought everything into disrepute. It's disgusting. So that's what the UN has found against New Zealand. That they did a crap job investigating things. Dr. Leakes just resigns from whatever medical council he is and then disappears. Absolved from any criminal liability. Why? Because the police interviewed 52 staff members and 1 victim out of over 200. So does that sound like a fair, independent and impartial investigation? Does it sound like the police did their job correctly? I don't think so. So, shit's going to change in this country, and it better change all around the world. We've just gone into stage 3 or level 3 of the coronavirus thing. So as from tomorrow midnight, Wednesday the 25th of March, strangely enough, just a week after last year's little shoot up in the mosques, New Zealand is going into full lockdown mode for 4 fucking weeks. So you can't go anywhere other to get food, medication or essential items. No one can go and meet anyone, no one can go and see anyone. Everybody is under basically house arrest. So we have no freedom of movement in New Zealand for the next 4 weeks, which is another violation of our rights. Now, they may say it's in the interest of public safety, but that old chestnut gets used far too often. And, you know, when I go out, I'm taking precautions. I'll wear masks, I'll wear gloves, just because I'm worried about my own family and bringing something home to them. They say to wash your hair, wash your clothes, all those sorts of things. Extra precautions. They aren't stupid ideas. But there's no point going overboard and bulk mass shopping. I mean, supermarkets have already started putting limits on the stock. But that's another story. So, until next time, much aroha, much love, and yeah, everybody out there, keep the mana, guys. Stay strong. No matter how long these authorities and state care decide to leave things hanging for over 40 years waiting for all the victims just basically to drop off the face of the earth. And I'm sure with the coronavirus they're all in that danger age. So I guess that's it. You're fucked. Anyway, enough of my ranting, guys. I've woken up with somewhat bitchy mood, and I felt it's only fair that I finish reading that out to you. See you guys. Bye.